Hello and welcome to a presentation on pregnancy discrimination by the Montana Human Rights Bureau. In order to understand pregnancy discrimination, let's first review what unlawful discrimination is generally. So what is unlawful discrimination? Well, it can simply be defined as an adverse action taken in a protected area against an individual because of his or her protected class status. To help us better understand the definition of discrimination, we're going to break down and define some of its terms. This slide shows a list of the protected areas under discrimination laws that the Bureau enforces. They include employment, public accommodations, governmental services, housing, education, insurance, and financial transactions. Here you see all the protected classes under federal and state laws. Montana's protected classes are the same and overlap with the federal protected classes, but note that Montana law recognizes the additional protected classes of creed, marital and familial status, vaccination status, and political belief, whereas federal law does not. Also note that the protected class of political belief is only applicable in the areas of governmental services and government employment, and familial status only applies to housing discrimination. Sex is a protected class under federal and state laws. The federal law that prohibits sex discrimination in the area of employment is Title VII of the Civil Rights Act of 1964. Montana's Governmental Code of Fair Practices and the Montana Human Rights Act are the state laws that prohibit sex discrimination in the various protected areas seen here. The protected class of sex contains several subcategories, which include biological sex, gender identity, sexual orientation, and pregnancy. In its simplest terms, pregnancy discrimination is treating a pregnant individual less favorably than a non-pregnant individual. In legal terms, we call this disparate treatment, which can manifest itself as unlawful discrimination in any of the protected areas covered earlier. However, in the area of employment, a pregnant person has certain rights as well, for example, a reasonable maternity leave. What is reasonable is not defined under the law, but is left up to the healthcare provider of the pregnant woman. It is not, however, determined by an arbitrary policy adopted by an employer. Using the state of Montana's policy as an example, it provides an employee with 6 weeks of maternity leave. However, if the employee needs more time for maternity leave, then she can provide her employer with medical verification of the additional need for leave. It's important to note that pregnancy is not considered a disability. Discrimination complaints related to pregnancy are filed with the Bureau under the protected class of sex. However, there are cases where a pregnancy results in the individual having or developing a condition that also falls within the definition of disability. An example is an atypical pregnancy wherein a doctor requires the woman to be on bed rest, or she has a severe case of morning sickness. If the pregnancy results in an impairment that substantially limits a major life activity, the pregnant woman falls within the protected class of disability as well as sex. If that is the case, as a person with a disability, she is entitled to reasonable accommodations for the disability. The Montana Human Rights Act, our state law that prohibits sex discrimination, has 2 specific provisions related to pregnancy in the area of employment. Section 49.2.310 of Montana Code Annotated provides 4 prohibited actions of employers. First, an employer cannot terminate a woman's employment because she's pregnant. Second, an employer cannot refuse reasonable leave for the pregnancy. Third, an employer cannot require mandatory maternity leave for an unreasonable length of time. And fourth, an employer cannot deny any accumulation of pay or leave benefits as accrued by a pregnant employee if that employee is disabled as a result of pregnancy. Section 49.2.311 of Montana Code Annotated provides that an employee who takes a pregnancy-related leave of absence must be reinstated to her original job or an equivalent position with the same pay, benefits, and seniority once she expresses an intent to return to work. The administrative rules of Montana also provide several rules related to pregnancy discrimination. Many of them cite back to the Montana Code and therefore may be repetitive to the statutes, but they are great to look at to gain further insight in this topic. And last but not least, the federal laws that relate to what we have been discussing are the Americans with Disabilities Act, if the pregnant individual develops a condition that qualifies as a disability, and Title VII for complaints of pregnancy discrimination. Montana's employers are often familiar with their obligations under the Federal Family Medical Leave Act, or FMLA, and may assume that because of the size of the company or the length of time an employee has worked for the company that there's no obligation to provide her with maternity leave. However, that's incorrect. This slide shows a side-by-side comparison of our state law, the Montana Human Rights Act, and the federal law of FMLA on 3 different points. Understand that the description of FMLA here is a bare bones basic description, and there are many other details to consider regarding FMLA coverage not listed here. But touching on these 3 points of comparison, under the FMLA, an employer has to provide maternity leave, but only if it's a covered employer, meaning they have 50 or more employees. And further, an employee can only claim the benefit after she's worked at the company for a certain number of benefit hours. But the requirements for the FMLA are different than under our Montana Human Rights Act. All employers, regardless of the number of employees, are covered by our Montana Human Rights Act. And further, it doesn't matter how many hours the employee has worked when she requests the leave. Additionally, leave time under the MHRA is whatever is reasonable and is not set to a certain number of weeks like under FMLA. Taking pregnancy as an example of a medical condition to see how the FMLA, ADA, and MHRA play out, first, under FMLA, if you're an employer with 50 or more employees and your employee has been there more than 12 months, she may be entitled to up to 12 weeks of leave. Second, then under the ADA, as we were just discussing, if the woman has an atypical pregnancy, an employer may have to provide reasonable accommodation to an employee or job applicant with a disability, unless doing so would cause significant difficulty or expense for the employer. And don't forget, leave can be an accommodation for disability as well. And third, then under the Montana Human Rights Act, even if it's a typical pregnancy, and even if you're not an employer with 50 or more employees, and the pregnant employee just began working for you yesterday, then the pregnant employee is entitled to a reasonable maternity leave. So to try to boil it down to a few takeaway points, let's go through some do's and don'ts regarding pregnant employees. First, let's talk about the don'ts. An employer cannot refuse to hire a pregnant applicant based on her pregnancy. An employer cannot discipline or discharge a pregnant employee based on her pregnancy. And an employer cannot force a pregnant employee to take an unreasonable leave of absence based on her pregnancy. Now let's focus on some do's. An employer must provide a reasonable maternity leave based on the recommendation of a medical provider. An employer must allow a pregnant employee to use accrued benefits and leave in the same manner afforded to non-pregnant employees. And an employer must ensure pregnant employees receive equal treatment in employment benefit plans. Here are some fun facts to leave you with. Although pregnancy discrimination laws are a bit different in that they provide specific obligations and prohibited acts for employers, don't forget that disparate treatment of pregnant employees falls under the Montana Human Rights Act as well. For example, the Bureau does not enforce Montana's laws that cover public employers' obligation to provide accommodations to mothers that are nursing or expressing milk. However, the Bureau does take, and has had, complaints where a female employee asserts her request for a break to express milk was denied while other employees were allowed to take breaks. This is a case of disparate treatment, or treating an employee differently than others based on sex. It may also be of interest to know that historically, 100% of the pregnancy discrimination complaints filed at the Bureau are in the area of employment and mainly in the service industry. Out of those filings, almost half allege that the charging party was discharged based on pregnancy. You should now have a basic understanding of pregnancy discrimination laws in Montana. For more information about discrimination or the Bureau, please visit our website at www.montanadiscrimination.com or call us toll-free at 1-800-542-0807 or locally at 406-444-2884.